In what some are calling a landmark decision in the law of malicious falsehood, the UK Supreme Court handed down its judgment this week in George and Cannell, unanimously holding that a claimant must show that the words complained of, viewed at the time of publication, were likely to cause financial loss to the claimant. In other words, it was not necessary to prove that financial loss had already been suffered. More radically, a majority of the court held that if liability is established but no financial loss has been suffered, then damages would not be recoverable for injury to feelings only. It has long held precedent that claimants are only expected to show general damages, not to prove special damages in order to receive compensation for malicious falsehoods. The court appears to have held that line in this week's judgment. The seismic shift, however, seems to be in emphasizing the importance under Section 3.1 of protecting financial interests while de-emphasizing compensation related to injury to feeling. The court finds that the statute's, quote, clear underlying purpose is to make it easier for claimants to recover damages in actions for malicious falsehood. However, where hurt feelings are no longer recoverable absent financial loss, it is hard to imagine a set of facts where that might be the case. Certainly, it's hard to imagine where a claimant would resort to a malicious falsehood claim over, say, a claim in libel. Further, it remains to be seen how this is implemented in the lower courts. Given Lords Hamlin's and Burroughs' dissent, that it is inconsistent to say that a claimant is not required to show actual loss to prove liability, but it is required to recover damages, it seems the issue might just be ripe for competing interpretations.